We tend to think of our legal system as this solid, permanent thing. But what if it wasn't? What if I told you that built right into the design of Canada's Constitution, there are these incredible safeguards designed to stop a total collapse of law and order? Well, that's exactly what we're going to dive into.
So just imagine for a second, you wake up one morning and every single law in your province is just gone. Traffic rules, property rights, marriage licenses, all of it vanished overnight. It sounds like something out of a sci-fi movie, right? But it's a real threat our legal system is actually built to prevent.
And believe it or not, this isn't just some wild hypothetical. Back in 1985, the Supreme Court of Canada stared this exact problem right in the face. A case called the Manitoba Language Reference created a full-blown constitutional crisis that literally threatened to plunge an entire province into chaos.
So how on earth did Manitoba get to the very brink of anarchy? Well, the story actually starts more than 100 years earlier, with a fundamental rule that was just ignored for almost a century.
Okay, so when Manitoba first joined Canada, its founding document, the Manitoba Act, had this really critical rule in Section 23. It's what lawyers call a manner and form requirement, which is basically a fancy way of saying it dictates how you have to make a law. And in this case, it said all provincial laws had to be passed and printed in both English and French, period. No exceptions. But here is the absolutely wild part. For nearly 100 years, starting around 1890, Manitoba just didn't do it. They passed all of their laws in English only. And we're not talking about a small mistake here. This was a massive, decades-long violation of a core constitutional rule. So, fast forward to 1985. The whole issue finally lands in front of the Supreme Court. And really, their hands were tied. They had no choice but to declare that every single law passed in English only since 1890 was unconstitutional. And when a law is unconstitutional, it has no force or effect, which meant that, all of a sudden, Manitoba was a province with no valid laws. This created this huge, unprecedented paradox for the judges. I mean, they were caught between two fundamental duties that seemed to completely contradict each other. On one hand, you've got this core principle that the Constitution is the supreme law of the land. The court's job is to enforce it, which means striking down any law that violates it. But on the other hand, the whole idea of the rule of law is that a society needs to be governed by, well, laws. A legal vacuum, a state of no laws, is pretty much the definition of chaos. So the question was, to uphold the rule of law, did they have to destroy it first? Faced with what seemed like an impossible choice, the Supreme Court came up with one of the most creative and, frankly, radical solutions in Canadian legal history. And it showed just how flexible our Constitution can be when it needs to be. The court realized that if they just stuck to the written text of the Constitution, it would lead to a dead end, to total chaos. So they looked deeper, to the unwritten principles that the whole system is built on. You can think of them like the invisible foundations of a house. You don't see them, but without them, the whole thing comes crashing down. And this quote from their decision really sums up their thinking. They basically used the idea of the rule of law against itself. They said, look, the whole point of the rule of law is to have a functioning legal order. Just wiping out all of Manitoba's laws would achieve the exact opposite. It would create chaos, not order. So what do they do? It was genius, really. They invented a brand new legal tool called a suspended declaration of invalidity. First, step one, they officially declared all the laws were invalid. That upholds the Constitution. But then, and this is the brilliant part, they suspended the effect of that declaration. They basically hit the pause button. This gave the Manitoba government a deadline, a grace period, to do the massive job of translating and properly repassing decades of legislation. I mean, just stop and think about how truly wild this is. The Supreme Court of Canada, the one body whose job it is to strike down unconstitutional laws, intentionally decided to keep an entire province's worth of unconstitutional laws alive and functioning. They used their own power to build a temporary legal bridge just to stop a province from falling into total anarchy. Now that Manitoba case was a reactive solution, right? A response to a crisis. But the Constitution also has proactive features built right in, designed to stop these legal voids from ever happening. And the first one is something called the principle of exhaustiveness. This is such a core part of how Canadian federalism is designed. All it means is that every single possible thing you could make a law about is assigned to someone. It either belongs to the federal government or it belongs to the provincial governments. There are, by design, no gaps. And the Supreme Court has been absolutely crystal clear about this. As they put it so perfectly in the same-sex marriage reference, a legislative void is precluded. It's just not supposed to happen. Some level of government somewhere always has the power to act. So you can kind of picture it like this. All the power to govern is one giant pie. The Constitution just slices that pie up. It gives some pieces to the federal government in Ottawa, and it gives the rest of the pieces to the provinces. There are no crumbs left over on the table. Every last bit of power is assigned. But, okay, what happens if a totally new issue comes up, something nobody in 1867 could have possibly dreamed of, like, say, gene editing or regulating the internet? What fills that potential gap? Well, that brings us to the final layer of protection, the ultimate constitutional safety net. This is the famous POG power. It's right there in the opening words of the federal government's powers, and it acts as a kind of catch-all. What it says is, if a subject of law isn't specifically given to the provinces, then it automatically falls to the federal government to regulate for the peace, order, and good government of Canada.
The POG power has a few different functions, but one of its most important jobs has always been to act as a gap filler. This means that when a new issue comes along that the founders couldn't possibly have imagined, POG ensures there's no legal black hole. That new area automatically has a home under federal authority.
So when you put it all together, you see this really elegant two-part system. First, the principle of exhaustiveness divides up all the known powers. And then, the POG power acts as the ultimate backstop for anything new or unassigned. It's a structure that is specifically designed to make sure our society is always and completely under the rule of law. That incredible crisis in Manitoba showed us that our Constitution is so much more than just the words on a page. It's this living, breathing framework with this hidden flexibility and a deep, deep resilience. And it really makes you wonder, doesn't it? If these unwritten principles can be called upon to literally save an entire legal system, what other hidden powers are just waiting there inside our Constitution to be discovered?